Also, my name is Deputy Montfort Tadia. I'm the chair of the panel.
I'm Deputy Max Andrews and I'm a panel member.
I'll just ask you to do the same, Minister.
Yes, I'm Ian Gorst, Minister.
Sean's.
Hello, I'm Niamh Moylan, Assistant Controller in Revenue Jersey.
Sean's.
Hello, I'm Niamh Moylan, Assistant Controller in Revenue Jersey.
Kate Nutt, Chief Officer External Relations.
Tom Lefevre, Director of External Relations.
Helen Delacour, Director of Financial and Professional Services.
And Thomas Wright, Senior Policy Advisor for Financial and Professional Services.
So welcome and thank you again for coming in to speak to us. Minister, we'll jump straight in with an area that's been of topical interest. There have been some questions raised in the States recently, both in terms of written and oral questions. There's a situation that's been described in that question period and in the media about the airport. Could you just talk to us and outline briefly, as much for the public record as anything else, what you understand the situation to be at the airport? Thank you.
Yeah, so firstly, the Office of Minister for External Relations is responsible for the legislation covering security at the airport, so compliance with civil aviation matters, which of course is separate from responsibility for the actual operation of the ports. That means that the Director of Civil Aviation operates within the remit of the department. They have an escalation procedure that mirrors that used by UK Civil Aviation Authority. And the airport was placed under special attention. That's the lowest level 1 on the 10th of December. And they normally those placing on that level 1 special attention would be confidential between the Director of Civil Aviation or the regulatory authority and the airport. But it became apparent that there was information in the public domain, and the Director of Civil Aviation therefore provided a high-level brief to me, which I think has now been provided confidentially to the Scrutiny panel. The Director of Civil Aviation was I suppose felt that there was a need to place the airport under level 1 special attention arising out of their restructuring. He didn't feel the need to provide me with details on that, but simply that the organisational restructure meant that it was appropriate for him to use the escalation process and to carry out reviews and audits on a more timely basis than might have been the case just under normal procedure. I'm expecting the Director of Civil Aviation to report back to me at the end of this month. As I understand it, there have been one external audit undertaken, which is would be a normal process, and the Director themselves or his office have undertaken other reviews as well. He confirms to me that they are confident that the airport remains safe and secure, and that islanders can be confident that it is operating safely and securely. But it is appropriate to put this special attention on the airport whilst issues that were raised by the DCA are undertaken by the airport. You will be aware that in the States last week I was asked a number of questions where I can only assume individuals had spoken to States members around issues that had happened at the airport. I have, subsequent to the State sitting, written to the DCA about those accusations, and I will also expect, when I get that report from the DCA, further briefing on those accusations and the veracity of them or not.
So, Minister, can you just confirm the point at which you became aware of the special attention that was when it was already in the public domain. Is that correct?
I think that's I don't know if it was in the public domain, but I understand that you in Scrutiny were written to by a member of the public. I think the brief was provided to me, I think it's on the 7th or the 8th of February. I suspect the letter that you received in Scrutiny was dated prior to that. The normal process for level 1 special attention would not involve anybody outside of either the DCA or the airport authority.
So just to confirm, so the process that took place, we were contacted by a member of the public. We then wrote to the Minister for Economic Development to ask for clarification, and then that was the point at which you were contacted to be given an explanation. Is that right?
Well, it was more that you wrote to the Minister for Sustainable Economic Development. I became aware of that.
What did I say? Did I not say that?
No, I'm just carrying on. You
thank
also
you.
said following on things.
Yeah.
I became aware of that, and rather I asked the question of the DCA, and that brief was then provided.
Okay.
The rationale for not doing it in advance was, as I said, level 1 special attention is the lowest level of the DCA's escalation process, and would not under normal circumstances or under circumstances elsewhere where airports are regulated would not involve political or ministerial briefing.
So there are other ministers involved, though, aren't there? So that, just to clarify, who's the shareholder for the airport?
Well, of course, the shareholder is the Minister for Treasury and Resources.
Can you confirm? So can you just confirm? I know, Minister, you're not here in that capacity, but as it's maybe a joint approach from ministers, what other ministries were informed at what point about this special attention?
So, as far as I know, from the DCA, no other ministers were informed other than myself, at which point certainly the Minister for Sustainable Economic Development became aware. I can't recall entirely when the Minister for Treasury and Resources became aware, but I wouldn't necessarily expect the Minister of Treasury and Resources to be made aware in her shareholder.
You recall, Minister?
In her shareholder function.
I couldn't tell the exact dates, no, but I was told there had been a restructuring.
Okay.
Where there were some very new and capable people were coming into work in Jersey Airport. And I can't remember when I knew about special attention, but my understanding of it was always that it was a relatively routine matter where you had new personnel. And it was simply because it was a change of personnel, the DCA was going to keep a closer eye on things till those people settled in. Now that was my understanding of it, and we have a no surprises policy among myself and the state-owned entities. I may have been told that on an ad hoc basis, but I can't remember timing. I genuinely can't remember timing.
Can you outline? We're aware that this is we've received a confidential briefing, so we're not fully aware of what's confidential and what's not. So we'll err to the side of caution, I think, to be circumspect. But could you tell us what's the link between a restructuring at the airport and the putting into of special attention?
My understanding of it was that it was simply because you had new personnel coming in, and maybe it's because of the nature of the role and the restructuring, because it was new personnel.
Okay.
It was just keeping an eye on things.
But new personnel
it wasn't
happen
necessarily raising a concern. It was just, you have a new person and we will just keep an eye on things.
But what's the link? Because I presume airports all the time bring in new personnel and they don't automatically go into special attention. So what's
Well,
the
I don't
cause?
think I don't know the reason, but perhaps it was because of the nature of the roles.
Yeah, so sorry if I can help. It's because of the substantial restructuring. It's not just a new person coming in to operate the X-ray machine or another new person coming in to work at the gates. It was a substantial restructuring of the ports of the airport, and it was that substantial restructuring where people were being either made redundant or retiring, and new people coming in, and it, to the Minister's point, at that point, when you've got a substantial restructuring of senior management roles, bearing in mind the airport isn't a massive organisation, it would, I'm only a layman, but even I can see it seems sensible that you would undertake audits on a more timely basis, and that the DCA would be reviewing the operation and how that restructuring was actually working in practice.
Do you have any questions?
No.
No.
Not
Minister,
at the
so does anyone else want to?
I was simply going to say, as the Minister said, I think it's a standardised part of the process that the DCA follows under the various levels. So for level 1, an organisational restructure such as that the ports went under would automatically come to the attention of the DCA, and he would conduct an additional audit out of the normal cycle. That's
Sure.
just, it's part of the process that.
So that bit's understood, but that doesn't necessarily automatically lead to the putting on a special attention level 1, does it?
It comes. I think it does.
It
I
does.
think level 1 kicks in
Yes.
when there is a significant restructure such as they've undertaken. It's just that's what happens as part of the process.
I'm not sure if that's our understanding. I understand that restructuring can happen in any airport, and that doesn't mean they'll automatically go into special attention.
I think because of the nature of the restructure in ports and the size of the restructure that was undertaken and the roles that were within scope, that was deemed relevant to level 1, and that's why it got caught by the DCA.
Okay. I mean, I think we're in a difficult position. My understanding might be slightly different to that. What I'd ask, Minister, is that there are two things. First of all, how can we ensure that these are clearly sensitive issues? There's an element of confidentiality that needs to be respected around airport security. But in terms of the public interest being served here, what seems to have happened here is that there's a whistleblower, for want of a better words, has contacted the panel, but also other states members, put some information out in the public domain. How do we scrutinise that, and how do we ensure that actually the restructuring that's been going on at the airport, that you're satisfied with what's going on? What's the appropriate level of ministerial and political oversight for an entity which is still 100% state-owned?
And that's a question. I'll come back to the bit about into the public domain. My responsibility, once the DCA confirmed to me in February that the airport was under special attention, and that was because of that substantial restructuring and the matching of roles and the experience and all of those things, was to ask the DCA quite simply, because I see it quite simply as, is the airport safe and secure, and can islanders be confident that the airport is safe and secure? And the DCA clearly said to me, I think he says it in the briefing note as well, that as far as he was concerned, the airport were responding to his requests that arose out of them being under special attention, and that they were taking the actions that were required to give him confidence, and that he was therefore confident that the airport was safe and secure. As we sit here, the airport is still in special attention, and I will be, as I say, expecting not only his report at the end of this month, but also a briefing on the answers to those questions that I'm not sure if they were the questions that the whistleblower made, but I've become aware through media as well that the questions that were asked of me in the States Assembly last week, whether there was a connection between those instances and the concerns that were around the restructure. So of course, once I've got both that report and a briefing on those issues, then I'll have to think very carefully how and what information can be put into the public domain, recognising that level 1 special attention would normally be between the regulator and the airport. As I said in the States Assembly, I think this has become a matter of public interest, and it's really important that we get the balance right between putting information in the public domain and protecting security procedures, because protecting security procedures means that the airport can operate safely and securely and not be the subject of bad actors seeking to use those processes for nefarious actions. I'm not yet able to tell the scrutiny panel exactly how I will manage the information that needs to be placed, I think, into the public domain. But we're having active consideration about how that can be done and what will be put in. And I suppose to some extent it might depend on whether special attention status level 1 is maintained for a future period. If that is the case, then I'd suspect more information needs to be put into the public domain. If it no longer is in special attention, then that will be a different scenario again. But still, islanders need to have reassurance around the safety and security of the operation of the airport.
And I suppose in future, would you speak to the airport and ports of Jersey about maybe a no surprises policy? So we get the relationship between the DCA and the airport is one thing, but the relationship between the airport and government is perhaps something which is within your purview. So in terms of I see that there are 3 ministers who are stakeholders. You've got the Treasury Minister, yourself, and Sustainable Economy Minister. Would you have expected to be told of these kind of things, or would you be interested in knowing of these things on a confidential basis so that you can be prepared if these things do come out?
So that's a question that really is quite impossible to answer, because there has to be Chinese walls between a regulator in government and the day-to-day operation of government, which is overseen by the Minister for Sustainable Economic Development, and the shareholder function, which is overseen by the Minister for Treasury and Resources. My focus has to be entirely on the role of the director, the office of the Director of Civil Aviation, and on safety and security. So having a conversation with the Director of Civil Aviation to see if we can get information despite the normal process of it remaining confidential as an early warning. I think there is merit in that, but it has to come through that channel and not from any other channel, because there has to be that Chinese wall.
Thank you. Are you happy with that?
Yes, indeed. Yeah.
Thank you.
Yep.
We'll move on. Thanks you for taking those questions at fairly short notice, Minister. I'll just pass over to my colleague, Deputy Andrews, for the next section.
Thank you, Chair. Moving on to Moneyval, the report that was published on the 24th of July of last year, already nearly 1 year. Minister, I just want to ask you, first of all, are we in a good position in terms of delivering upon the findings of the Moneyval report? And if so, will many of the things that have been identified be delivered upon before the next election?
Well, I suppose the first thing to say is that it was important that we got a good report from Moneyval, because it was only in getting a good report that meant that we weren't grey listed and that we didn't have to go through that, what we all know is a very damaging process, but also a very painful and costly process. So, of course, we want to meet the international standards and the 11 immediate outcomes, and we did it very well on that. But with any international standards process like this, there's always room for improvements, and there's always changes in the way that you are being assessed. We know that we're moving from the 5th to the 6th round of assessment, and so the basis for assessment will change again. Officials are only right now this week at Strasbourg, are they in Strasbourg, at these sessions now, where those 6th rounds are being kicked off and almost starting. So we have to be, what we've done in government is to merge those two bits of government together. So Helen is now responsible for both financial services policy and financial crime policy as well. And that all comes together under her in a way that we didn't do before. We have taken this opportunity post the report to focus now on our competitive advantage. That doesn't mean that we aren't also doing the work that came out of the recommendations of the report. So as you will be aware, this quarter we've got the proliferation financing risk assessment that's been published. We've got typology reports on dual use goods, which will support detection and compliance in the private sector. We've got the JFSC consultation paper published proposing enhanced criminal background checks for individuals in key roles, and we've got the ongoing work of the FIU.
Yeah. And Minister, just touching on from the point that you mentioned, the regulator, the Jersey Financial Services Commission, how well placed are they now compared to last year, following on from the publication of the Moneyval report?
Well, there's two. So if we just step back from the Moneyval process for a minute, they will of course have to keep doing the things that are necessary to ensure that we can be compliant. But we come back then to the work of the competitiveness programme, and we're working, Helen's team, and Helen as an individual is working very closely with the regulator in various pieces of work around the competitiveness programme. The regulator themselves are thinking about their own strategic direction, and they're engaging with us on that as well. They're also doing work around the registry and thinking about what does a register look like for the future. So there's a lot of ongoing work.
There are questions about the competitive programme that will be followed up by Deputy Tang.
Okay.
But I just wanted to ask whether you are confident that the Jersey Financial Services Commission have all of the resources available for them to discharge their duties as a regulator.
Well, that's an interesting question, because I normally get told that they're over-resourced and overstaffed. During the process of the Moneyval assessment, we did do some international comparisons between the resource and the headcount at the regulator, and unless I'm misremembering, it was broadly in line with international comparisons, and therefore I think that they are appropriately resourced and staffed. Of course, use of technology is potentially going to change some of that, and the need for the resource in the way that they currently have it, but that's a future question.
Yeah. And are you confident that progress has been made in terms of seeing industry embrace some of the findings that were made in the report, and have you seen some of those changes be implemented as well?
Well, I think obviously Moneyval is really focusing on the agencies and the things that they need to do, and all of the agencies are doing their work.
Yeah. Okay. Thank you very much, Chair.
Thank you. Minister, we're going to talk a little bit about the competitiveness programme, hopefully, if that's okay, which you've touched on already. Well, my first question is, what do you see as the growth opportunities for Jersey's finance sector in the short and medium term?
Well, if I had answer to that. I wouldn't need to do the work, is the flippant reply. So this work really is about ensuring that we strengthen our competitive edge in that global marketplace, that we improve our regulatory and business environment, that we make sure that we're positioning Jersey internationally correctly, and that we're preparing for future challenges and opportunities. I suppose if I had one mission that I think we are about, it's seeking to ensure that we strengthen Jersey as the go-to jurisdiction for those who want an international finance centre and want that denominated in sterling. So the Sterling International Finance Centre of choice is what I am seeing as the overarching mission to drive all this work forward. And that's why we've got these 4 streams of work to deliver that.
So do you see it on the one hand, is there any tension or overlap between enhancing what Jersey's financial sector already does well, or looking to develop new ways of working that maybe can attract and enhance growth?
Well, it's both, isn't it? Yeah, I think in the premise of your question, it really is that we need to do both. It's not. I know it's a truism to say that if you're standing still, you're going backwards. But in this sector, that is the case. If you're not winning new business, you're not winning new funds, you're not winning new family offices, you're not winning new deposits, then you are ultimately going backwards. But the core strength that we have, which is that government, regulator and industry work closely together, that we can be fast and nimble, that we can have appropriate regulation, those core things need to be revisited and strengthened, because 60 years of being a successful finance centre inevitably means that in places we've become bureaucratic, in places we've not been innovative or flexible. Somebody was saying to me the other day, and they're right, that new industries flourish outside of regulation. That's just their very nature, because they're new. Nobody's thought about how to regulate them or what regulation is required, and we can all think of some of those industries. The challenge for a mature industry like financial and business services in Jersey is how you reimagine that regulation and make sure that it's not stifling the growth of the sector, and that it meets with the international standards, but it does so in an appropriate risk managed, balanced way.
Can I just ask, Minister, you've spoken about regulation, but also have you received any feedback from any entities regarding the cost of doing business in Jersey?
Yeah, so that is I always think that's a really interesting question. So Helen will be able to, if we want to go into any detail, but Helen is leading work stream 2, just make sure I get its name correct, the business and regulatory environment work stream. She has used a local law come consultancy firm. They've gone out to industry. They've had something like 100 interviews. They've had user workshop groups that was conducted in March and May, and she's done that in concert with Revenue Jersey and the JFSC. Sorry, just go back to your question again.
So this was about, have you received any responses from any entities regarding the cost of doing business in Jersey?
Yeah, so interestingly, the cost of doing business in Jersey isn't the cost of company fees and things like that. It to some extent is the cost of time, and that's related to bureaucracy and the way that we currently regulate. We know that Jersey lawyers are not the cheapest in the world. Jersey banks are not the cheapest in the world. Jersey trust companies are very good value for money, but I've got to be careful not to be partial. So we know that you've got that cost base built in. But actually, the real cost of doing business in Jersey is much more about the time, the cost of time. And if we can narrow down, if we can use technology and reduce all of that time cost, then our core costs are comparable with and better than other jurisdictions that we compete with.
Yeah, but do you see it being a potential problem if we see firms adopting, say, artificial intelligence, for instance, and will we then see an actual displacement of labour, or do you not have any concerns about that? Do you think
I
people will be fine?
I don't see it as a
No.
problem. I see it as a great opportunity for business and financial services. It comes back again to your point about cost. If you can do things more effectively and more efficiently and they take less time, then the on cost to the client is reduced. And I think that you've got to think about we've got to be careful not to think sci-fi when we think about AI. We've just got to think about large language models and the use of information combined with technology that will help us do lots of analytical work in a shorter time. I mean, I was talking to somebody last week about a piece of technology that would answer the question that we've been struggling with in Jersey for a long time. I want to come and set up a company in Jersey. So I have an introducer, London law firm. Well, firstly, of course, I've had to give all my CDD stuff to them. They introduced me to a Jersey law firm. Unless it's a sub, they have to provide it all again. We introduce you to a trust company, do it all again. The bank wants it all again. This is a piece of technology whereby you can provide the source information once. It has an audit of where it's come from, and then others can use that information because they're networked into it. And so you provide it once, trust company, lawyer, bank, they do all their risk assessment and they have their internal risk profile, but the source document is produced once in this technology. And there's no reason to my mind why the regulator can't do that as well.
So, Minister,
we are using technology to reduce that time.
Yeah. But Minister, do you expect the number of jobs in finance to diminish with the adoption of technology, or do you happen to believe that there will be the creation of new jobs as well?
Well, that will, to some extent, depend on how successful we are, not just with this piece of work, but with all of our support for economic work. Because what we're seeking to do is recognise there are all these headwinds, which I think can be used positively, and win more work and attract more businesses to Jersey. And people are then moving through the skills level, because if we can only win quality business, that quality business requires human interaction, but it doesn't require human interaction all the way down the line. But it does require human interaction at certain levels, and that's what Jersey's skilled at, and that's where we should focus our growth potential and let AI and technology deal with the other jobs where we know that they're going elsewhere anyway. We've been outsourcing some of the sorts of jobs that tech can now help us with to other jurisdictions for a long, long time anyway. We must focus on making sure that we grow and that we have a sustainable financial services centre in the continued trajectory of the high value, so that we can maintain and grow what we've got.
Thank you, Chair.
Minister, I'd like to ask some questions about risk appetite in the context of competitiveness. I've got an allotment. I don't know if you're aware of that, and I operate an allotment. Yeah,
I didn't
it's a
know
gardening.
that. I didn't know that.
And I operate quite an unregulated system.
We can
with
talk
my
about
allotment.
cabbages outside of
We
this.
can do.
I didn't know that.
It's not quite election time yet, Minister, but I operate an unregulated system by and large in my allotment, and I find that it's caused quite a lot of growth to occur. in the allotment, but it's not necessarily the type of growth that I want. Is there a reasonable analogy that can be made with Jersey's finance sector in terms of the risk between regulation and therefore promoting good actors and conventional, if you like, versus complete unregulation on the one hand, deregulation, which might result in a lot of growth, but the need for weeding out to take place later on. So what do you see as a sweet spot in terms of where Jersey needs to be from a regulatory point of view?
Well, I don't see it in terms of allotments. Won't surprise you too.
I thought you might enjoy a good analogy.
In that regard, because a good regulatory and a sound regulatory environment meeting the international standards is the basis upon which we've been successful for these last 6 or more decades. But the question is, does the bureaucracy that we have in place, and does all of the legislation we have in place, lead to us being, does it enhance or diminish from what we are doing? Does it actually manage the risk, or does it give the impression of managing the risk because you've got all these boxes ticked? Or are we better to, which is where I think we're going to say, we've got fantastic organisations, we've got great lawyers, we've got great trust companies and banks. They understand their clients, they can get to know their clients, they can understand the risk of individuals and businesses, and go back to what we really think and what really helped us in the past, which is we really are thinking proportionately and in a balanced way about risk. So these conversations are live. I've been having these conversations with interlocutors because it is a really important question. Is the legislation and the bureaucracy that we've got in place actually dealing with risk, or is it just making us uncompetitive? And in lots of cases, or in a number of cases, it's making us uncompetitive and it's not helping us manage the risk. The Moneyval assessment said it gave us, I think it gave us the highest possible grading for understanding risk. So if we understand risk out there in industry, we understand it from a policy perspective because we know a centre of cross-border flows brings with it risks. We understand those risks. Then we ask the question, is the way that we're dealing with regulation appropriate to those risks, and is it helping us mitigate and manage those risks? That's what we're trying to do.
Okay. And have there been any specific actions formed in the competitiveness programme in terms of likely?
So we are. So we've got these 4 work streams, which I know you know about already, which is the first one is international tax. There's lots of ongoing actions around international tax, not least thinking about delivery of Pillar 2 and all of that work. In work stream 2, the one that Helen's leading, we're going to do a public public industry event that we're going to invite all states members to on the 23rd of July, where we will talk about the actions that we've been taking and further actions that we'll then take throughout the rest of the period of this programme and beyond. So there are a number of actions that Helen is implementing now, but we're going to bring those all together at the July event, and hopefully at least some members of the panel can attend that. And then we've got the external growth strategy work. That's just in progress of us finding somebody to undertake that work. We've not signed and sealed that yet. It's being led by JFL, and then we've got the bringing of it all together in work stream 4, which is into next year.
Thank you.
Yeah, thank you, Chair. Minister, can you outline whether there are any implications regarding resourcing for the competitiveness programme?
So as you know, the previous government plan forecast a number for Pillar 2 receipts. we are working through the FPP economic assumptions and the income forecasting group. That may have implications for the amount that we've earmarked for the future competitiveness work, but the current work that we are undertaking is all being undertaken within the existing budget that the states agreed for the financial services division of the economy unit last December.
Yeah. And can I also ask?
Or was it November? Did we do the budget in November last year? November, sorry.
Can I also ask a further question regarding the recruitment freeze? I was wondering whether this has impacted your department, and have there been any implications where roles would have otherwise been filled?
So there's no, we'll just take each division slightly separately there. So it is no doubt the case, to my mind, that the consultancy and recruitment freeze to date has meant that we have got funding available within Helen's section to allow us to undertake the work that we did in Workstream 2 using a local consultancy and law firm, and that was very well received in industry. The work that we're going to be signing and sealing in Workstream 3 using an external global consultancy body as well. It means that we'll be able to fund that from within our existing budget. But whilst the Chief Minister, of course, has been really firm in the criteria for exceptions to consultancy work, and there is some other bits of work within the department that we're not doing because we haven't got permission to do that, but it does allow us to focus on this work. There is a recognition, of course, that there are certain pieces of work, and health are the same. They have to have external consultants to help with them. Infrastructure are the same. And here, if we are serious about making sure our economy remains competitive and grows, we need the support of externals as well. And although it's been a really rigorous process, there is a recognition by the CEO and the Chief Minister that this is work that needs to be undertaken. We restructured in financial services, as said, post-Moneyval, and that was to reduce our cost base, but in that, so reducing senior roles, which meant that we had more junior roles to be able to fill to take up some of that work. So we are recruiting for some of those, but not all of them. No. But we're managing, I think, which is what Chief Minister and CEO want. We're doing more within our existing budget because we're managing to control these very things. In external relations, we are also managing our budget and managing headcount as well.
Okay, that's very good to know. I'll just move on to the next section regarding the banking review, and I just wanted to know, Minister, what stage are we at in regards to this review?
The banking questions I'm going to pass to my Assistant Minister, or I don't know if you want to do it or you want Tom to do it.
We didn't. I think the banking review happened really over, well, it started in 21 and 2022, which generated a series of pieces of work, some of which have progressed, some of which are haven't progressed. But I think the banking piece, because in the wider competitiveness programme, the banks really are quite fundamental to the whole financial services framework in Jersey. So it doesn't make any sense to leave them out of that piece of work. So the whole bank review piece will roll into the competitiveness piece of work as well.
Okay, well, that's very good to know, because that was something that the panel were pondering. But Minister, I do need to ask, you mentioned about some pieces of work that have not been continued, and I just want to know why has that been the case?
I think I'd expect really largely due to resources. Tom, you've got more details?
So I think there's some pieces of work, for example, we look to open banking, but this is one of the pieces that has been put on hold as we look to the competitiveness piece of work. We've talked with the panel previously about open banking, open financing, which is enabling that intermediary platform-based service providers to sit in between banks and maybe financial institutions or customers. So even though that's something we see as a global trend, it's something that we need to consider where, as Jersey, it's right for us to take that piece of work. So I understand it's been put on hold to consider within the broader context of the competitiveness review, at least the strategic piece of work within competitiveness review. The banking review work, which was there's a series of work performed in 2022, it did feed in many directions, purely because it's quite a broad considered piece of work, and inevitably, because banks cut across the whole of society and the whole of industry, it's fed into the other piece of work we've been doing. For example, the consideration of the regulatory environment, which again, it identified the need to look into that, and that's exactly why that's then forming part of that piece of work, along with other reasons why it then formed part of that piece of work. The review also identified the need to continue to deliver other items that we had on the cards. For example, we had a piece of work on digital ID that we moved over the line and we delivered upon. And it's very much there are still things to deliver on that from a strategic perspective.
Thank you very much for your time, for responding to me on that question. Minister, I just wanted to ask, are you aware of how many banks operate in the island?
I want to say 19.
There's 19 licenses, yeah.
19 licenses.
Okay, and
Which
that,
may be within the same group. There may be more than one license within a particular banking group, depending on how they structure their operations in Jersey.
and Minister, I also just wanted to ask a question regarding what actions do you believe ought to be taken to encourage more businesses, more banks to come to the island?
Well, hopefully the competitiveness review will help us with that. I think the GFSC used to have quite a strict policy in terms of which banks they would allow in. It was, you had to be in was it top 500? So I think that has been relaxed a little bit.
To 1,000.
So for quite some time. So I think really we have last year before there were lots of inquiries, but setting up a bank in a new jurisdiction is quite a big piece of work. But I think clearly the main clearing banks are here. There were banks that were here previously who have gone. It may be they'll come back, and often banks make decisions based on wider global strategies. And there are some banks who have been here, they've divested operations, they then buy back into those very same operations, and they as their strategy and their own outlook changes, what they want to do or not do in Jersey will also change. But yes, if we have more banks coming, that is a good sign. And I think some of the smaller ones have left due to maybe they just didn't have the scale here.
And Minister, are you aware of the reasons that have been given for some of the banks who've perhaps relocated, say, within the last few years?
Not specifically.
I think if we look to the last few years, you're talking more one of consolidation within industry. You've seen other banks purchasing other parts of other banks, and that's really a trend that started from 2009 onwards of de-risking in banks. De-risking probably more from a commercial risk perspective to consider and focus their own product lines and services. So we've seen that de-risking, we've seen that consolidation. The industry looks very different from 20 years ago in terms of banks. You can't see so many licenses. And I think, as the Minister says, it's one of considering, we want to make sure we've got the environment where the right banks can come to the island. But at the same time, I think this piece of work that's going on with competitiveness will allow us to consider services that we may wish to encourage on island and how we make the environment to enable that, but then recognising there might be limitations in that, and there will be an inevitable need for some services to be sought.
Thank you.
Thank you, Minister. I'd like to just move on maybe briefly to the area of double taxation, the DTAs, as we might call them. I'm specifically going to start with the question about where we are in working on a double taxation agreement with France, because it does seem to be an area of public interest. We do routinely get correspondence from constituents because they're potentially retiring there, and at the moment they seem to be in a financially adverse position because of the lack of a double taxation agreement. Could you talk to that, whether globally you're supportive of moving to that position and what the challenges are and the steps are to get there?
Yeah, so I don't think it's that there's any support. So, of course, there is already a partial DTA from 1964, which eliminated double tax on aircraft and shipping, but doesn't really deal with the individuals. Yeah, well, your constituent. Doesn't help your constituent, probably. Pension income is also protected from double taxation through an article included in the French Tax Information Exchange Agreement from 2010. We've had numerous engagements with the French government, be that in Paris, be that through the embassy in London, be it through on-island visits. It's an issue that we continually raise about upgrading, in effect, our current treaty arrangements. But unfortunately, a full DTA is, we've been clearly told, not of interest to the French at this time, but we will continue to make the case because we recognise the broader benefits.
Is there any extension of a partial DTA that might be of benefit to?
Yes, well, that's where the conversation really focuses on. Can that be? I use the word upgrade, but you use the word extension. Yeah. That partly is what where our conversations are focused. Tom, you are the international. No, you said Neve. Either of you can. If you've got anything else to add your two.
I just wondered, Neve, on the tier, whether you wanted.
Well, I mean, I would say that we do periodically reach out to the French authorities, most recently in connection with discussions around BEPS, the OECD's base erosion and profit shifting project, and its impact on double tax agreements. I think it is very clear, and it has been very clear on multiple occasions, as the Minister said, that the appetite just isn't there, unfortunately, on the part of the French.
Okay.
But we will continue to raise it, as you said she does as well.
Do you feel that you've got a handle on what the issues are from the Jersey perspective, so the user's point of view who might be in receipt of facing double taxation? Or would you value hearing from more members of the public? Or
I think, if you're the tax person, I suspect you've got a handle, but if any members want to write into the Revenue Jersey, then please feel free to, because any what's the word I shouldn't use the word ammunition, but if there's further evidence that we can present to the counterparty and what the benefits would be, then that's always useful.
thank you. So we also note that amended taxation agreements with Ireland and Mauritius where are we with those? Have they been implemented?
Those have been completed, so we've completed the updates to them. Those were done to maintain Jersey's alignment with international minimum standards. So Neve just mentioned BEPS, which is base erosion and profit shifting, for anybody who's listening and is not an expert on all this stuff. And that requires us to make amendments to our treaties to bring them into compliance. That has been done, and that work is completed. I think in the coming months there are going to be some more updates to Jersey's existing treaties for BEPS compliance, and I think we have quite a well-established process of notifying the panel in advance of those being presented in the usual way. We're also engaged in a broader ongoing programme of discussions with other DTA partners, and with any luck, the Minister will be making some outbound travel over the course of the autumn to allow for signing of those concluded texts.
Are there? I noticed there's a British and Irish Council coming up. Is there?
Yep.
On Thursday and Friday
Thursday.
this week.
Will double taxation agreements figure in any of those discussions?
It shouldn't be this time, but it's a good question because we signed the update to the Irish agreement in the margins of a prior British-Irish Council meeting, so they can act as a good forum for bilateral business, but we have already done that this time around.
And how do you identify more generally where a double taxation might be beneficial and then feasible? Do you have a way of going through that process?
Yeah, sure. Very happy to do that. Well, there are sort of two aspects, I think, to where we think about the benefit to Jersey. So taking them in turn and not in order of priority. I think historically and primarily when we thought about full double taxation agreements, we've been thinking about the benefits to Jersey companies that can be provided. And so the focus there is around understanding which markets, which jurisdictions are particularly important for Jersey businesses. And we have quite an established methodology actually for looking at jurisdictions and trying to identify whether there is value and growth for Jersey businesses. That's because of the provisions in the double taxation agreement that are most relevant to cross-border flows. So that's around rates of withholding tax, where that's the tax that's levied on interest, dividends, royalties, and you're looking to secure a favourable treaty rate that's lower typically than the national rate. But the other area that is also relevant is more linked to your earlier question around the impact on individuals, because full agreements don't just confer benefits to companies, they also do it for natural persons, for people. And there we've done some work recently to think about, well, where are the jurisdictions where we are increasingly seeing nationals of other jurisdictions coming to work for Jersey? The sorts of issues that DTAs can sort out is where you may have an individual who's spending part of a given tax period working in Jersey, for example, during a busy summer season, and then returning to a home jurisdiction. And you need agreements between those two places to work out who has the taxing rights over what and when. And that clarity can be a useful tool in our armoury when we're sort of trying to attract workers to come. I'd say sort of more, so we have an established process, and I'd be very happy to offer a more detailed briefing on exactly how our methodology works for thinking about jurisdictions. We call it our horizontal analysis that we do. We have done that for other previous panels. The other thing I would say just more generally is all of these questions, at the risk of sounding like the competitiveness programme, has lots of things going into it, but they are relevant for the competitiveness work under Workstream 3, and in particular where that's thinking about overseas value pools, which are the priority growth sub-geographies and sub-products for Jersey. That should give us some fresh information about what we're seeing out in the market and where we think some of the business of the future could lie for Jersey.
And can I just ask that there presumably has to be benefit or perceived benefit on both sides, of both for Jersey and the signatory on the other side.
Yeah.
When it comes to the BEPS, so the base erosion profit shifting, is that something that's put in by Jersey usually, or is that a counter requirement which is often put in by the other country?
So I'll start, and I don't know if Niamh wants to go in. So Jersey's model treaty includes all the BEPS minimum standards because Jersey is a full BEPS associate. We've signed up to it. And so when we're going out to negotiate, our treaties have all of those provisions. The updates for Ireland and Mauritius, by way of example, are because we had agreements that predated those changes coming into effect. So all jurisdictions that sign up to it have to bring into effect those new provisions into their existing treaties. That you're absolutely right to say that all treaties are a matter of negotiation. If we have negotiations with a fellow BEPS associate, then of course on both sides you will have a match in terms of those provisions because they apply equally to all treaty partners. But it is true that not everywhere in the world is signed up to the BEPS programme. I don't know, Niamh, whether you want to add to that.
I think that was a very good summary. I mean, ultimately, it's negotiation, and increasingly we are seeing that partners are also looking to other models, particularly the United Nations model, which is slightly different in different areas. So it very much hinges on the balance of the agreement with each partner jurisdiction.
Thank you for that. I'm going to move on to some questions about trust, if that's okay. So, specifically the Trust Jersey Law 1984.
Yeah.
All on the same page.
The amendments to it.
Yeah, I mean, so I'm mindful. I think we're making good progress, but we're in the last half an hour of our hearing, so I'll try and keep the questions punchy, and maybe we can do the same with the answers. So the panel understands that the amendments to the trust law can be anticipated to be lodged shortly. Can you provide a brief outline of the purpose of these amendments?
Yeah, so as you know, the Jersey Trust Law is a flexible piece of legislation by intent, but from time to time, if there's been specific issues brought to our attention or specific judgments that need clarification in the legislation, then that's how we deal with it. They're quite technical, really. There's one area is confirmation of priority of claims between a former and current trustee on the one hand and a secured lender on the other, given the recent case of RZ. So this amendment will clear up that position and give clarity to secured lenders that they do have priority in an insolvency over a trustee. Then we've got the change around beneficiaries' ability to call for the termination of a trust in certain circumstances. That's confirmed as being where other beneficiaries cannot be appointed. Then we've got changes around clarifying that a sole trustee cannot resign if that would mean there were no trustees for the trust. And at that same point, we went out thinking about, in that consultation, we also started to think about data trusts, but we did go to do further work on that as well. And then there are some minor corrections as well.
Can I just ask, Minister, you mentioned about if there was, say, one sole trustee who's in a position where they wanted to resign, and it would obviously not be tenable for them to do so. But I just want to know whether there are any implications if there is somebody who has to maintain themselves as a trustee who doesn't want to hold that position any further.
Well, of course there are, because what needs to happen is that one needs to find a trustee that the trust can be assigned to. That's something that normally there would be support for from the JFSC to do that assignment. But it's really important that the trust itself doesn't fall over because there's no trustee.
And do you think there could have perhaps been an elaboration in terms of there being a defined and explicit process in regard to the appointment of a new trustee to replace the person who wants to step down?
I don't think so. I think flexibility is key to enable it to happen. The other option would have been, of course, which is something that whenever we've looked at it, it just becomes costly and bureaucratic, is the use of a public trustee, but this is a sort of a way of solving that problem.
Yeah, I think Jersey's trust law is probably the greatest asset of the private wealth industry in Jersey. What we don't want to do is codify absolutely everything, and not to forget that trustees have fiduciary duties that will be ongoing until that point that the trust is under administration somewhere else.
Thank you. So is that generally how it works? There'd be a court judgment, and then that might indicate that there were amendments that need to come forward, or
it would either be that, and the industry working groups would want clarification, or we would look at it and think that's not how it's been working in practice, so we need to make that change so it does work, it's clear. And sometimes a judge in their judgment will suggest that there should be clarificatory amendments made as well.
Okay. So there was a consultation undertaken in 2024, I think, was that right, on proposed changes. So were the stakeholders supportive of the changes that are being put forward?
Yeah, so let's just say it's an iterative process. I've got to be careful not to praise her too much. We have a good trust person in the department. She is well respected in the trust industry, and she has got a good grip of the details and the implications, and she manages all of this dialogue with the trust working group. and she has not said that there are any concerns.
No.
More, I would expect that there was full support for it.
Yeah, absolutely. And there will be a response to that consultation forthcoming. I think just with the pressures we have on the legislative timetable this year, we want to finalise the legislation for drafting before we can put forward that. But there is ongoing engagement with those who responded and a specific trust law working group.
Yeah. And could I just ask, in terms of numbers, what's the kind of numbers we're talking about with stakeholders who actively respond or are involved? First of all, within that working group, but more widely, is it fairly niche, if I can use that term?
I think it's safe to say it's fairly niche.
Yeah.
Yeah.
I don't know how many.
I don't
people
know
are on
the
trust
numbers off
working
the
group.
top of my head. There's normally around 10 representatives, I'd say, on average, from the different trust companies, law firms as well, and the JFSC would normally attend the working groups.
Yes. Thank you, that's fine. Deputy Andrews, are you happy to carry on with banking recovery and the compensation scheme?
Yes, indeed. The panel has previously raised questions, Minister, regarding the depositors' compensation scheme, and the panel also understands the response that you provided in terms of not bringing forward any proposals before 2026. However, after such a date, is the Minister of the view that something ought to be changed, and if not, then why not?
Sorry, proposals for
Changing
changing the amount. I think the focus at the moment is on merging the deposit compensation scheme into the Jersey Resolution Authority, which is a completely sensible thing to do, because it is important that if there was a failure, that the deposit compensation would be paid quickly and effectively and within international standards. And by moving it into the JRA, that facilitates that process. So it makes administrative changes, it means you've got one point of decision making, and that will take some time to bed down. The deposit level that we have at the moment is the same as Guernsey and Isle of Man. The question of raising it does come up, but we have to remember that we are a small jurisdiction, and we have to have limits that reflect, that are proportionate and appropriate for Jersey. So I think there isn't a specific, I think we're going to, once this is bedded down, the question of limits would possibly come up for review at that point, but it's not on a work plan at present.
Okay. What discussions have taken place with the JRA in terms of bank recovery and resolution since you took office?
Well, there will be ongoing discussions with them. I mean, they are there. I mean, I think what the JRA do is they work with the regulator and other stakeholders in terms of planning what would, I mean, I'm going back to my previous life on this, in terms of working what would happen if there was a bank failure. Now, there is lots of work goes on all the time, so the Commission will regularly be looking at bank prudential status, so how stable are they? They do stress testing exercises, they review bank finances, because the last thing that anybody wants is a bank failure, particularly not against a systemically significant bank in Jersey. So they conduct that ongoing work, and then they are ready, they should be ready to use the tools so that if there was some kind of flag, let's say an amber flag in the first instance, raised about a bank, they could be speaking to that bank with the regulator to look at what can be done in the immediate instance to avert any form of failure. And they will work through a number of resolution tools, which may be bailing in senior creditors, if you want to put it that way, and various other resolution tools in terms of more capital raising to avoid a failure.
Yeah. Have any issues been raised during your time in office regarding, for instance, some of the balance sheets of some of the banks?
Not that I'm aware of, but I don't think we're necessarily
No, not specifically.
any commercially sensitive.
No.
I mean, we know obviously what's happening, what the UK thinking has been about the required capital.
Yeah.
There's often conversations from time to time about, is the required amount of capital necessary or could we look at that and adjust it downward? So I mean, you know.
Can I just ask, Minister, obviously I don't want to ask questions that are potentially politically very sensitive, but have you noticed there is a change when you are speaking to your counterpart in the UK, who is now part of the UK Labour government, compared to the Conservative government, and the perception of what they view Jersey to be as an international centre?
Well, when you say my counterpart, there are many counterparts. So if you think about our counterpart in Treasury, she is an individual that worked for City UK and knows the City of London and knows offshore international finance centres very well. We have good support from Lord Ponsonby. We've got a good relationship with Nick Thomas Simmons at the Cabinet Office. We've got a good relationship with the Business Secretary. So we are constantly seeking to build understanding and knowledge and value that Jersey actually brings to the UK economy. You look at the Department for Business, their own figures show that Jersey is responsible for about 10% of foreign direct investment into the UK economy. That's not a Jersey figure, that's a UK departmental figure. So we think that the Jersey financial services sector brings value to the UK economy and supports the new government in its agenda for jobs and growth.
Yeah, no, thank you very much, Minister. Obviously, the panel understands that P42 2025 has been lodged, and I just want to understand what is the rationale behind the lodging of such a proposition, and why will it be so crucial that it is passed in the Assembly?
What is P42?
This is regarding Bank Recovery and Resolution, Jersey.
Yes, well, P42, as I say, that is the piece of law that will move the deposit compensation scheme into the GRA. It doesn't affect the scheme. The scheme itself continues as is, but it will make some administrative enhancements. It will also make some enhancements to the resolution law itself to ensure that can work in a practical fashion. You know, for example, at the moment, I think the deposit compensation scheme law itself, which I think goes back to about 2009, 2010, although I was talking about it in the late 90s again, it says if you're a depositor, you must make an application for payment. You'll have to provide certain information, and what we'd like to work towards, what we're aiming to work towards, is a position where the GRA would just receive depositor data from the banks and can just pay out cheques automatically, can pay them out within, I think, 7 days, which is meeting international standards. So it's enhancing the scheme and making it better, while at the same time, with the whole resolution framework, trying to avert the possibility of a failure and the need for compensation in the first place, because the last thing that anybody wants is a bank failure would be very stressful for depositors who are owed money by the bank, because it's a debt, obviously, but it would be very stressful for everybody involved, everybody who, whether you're a borrower, because does your loan become repayable? If you're a borrower in more other sense, now clearly you still have contractual rights as a borrower, and the bank can't come and say, I want your mortgage money back next week. But it would be incredibly stressful for everybody. So the whole resolution framework is trying to make sure that our banks are on a sound financial footing, and if there is any wobble, that they can be supported and returned to sound financial footing, rather than collapsing.
Okay, thank you very much, Minister. Chair?
Yeah, can I just ask, is the £100 million limit which is being removed, is that for the global amount that can be compensated? It's not per company, is it? Because there's a cap for
I think that's
50,000.
global.
Yeah, so the 100 million, what's being removed is the £100 million cap on payout, which exists in the current scheme. And what that means is when you hit that payout, then you would have to seek any monies that you haven't received from the liquidator. What removing that cap means is that the scheme, through the operation of the authority, can continue to try and make faster payment by recovering the money from the liquidator. They probably have the ability as a larger, as a pool of depositors to actually claim that money back from the liquidator and distribute it through their processes with some,
Okay.
I wouldn't say relative speed, but with more efficiency.
So can I go back to the £50,000 cap? So the UK increased their figure from 50,000 to 85,000, I think, back in 2010. Has Jersey not, has Jersey's government does it not look at reviewing that periodically? And because in real terms that value is declining year on year for investors.
Yes, but I think you have to, well, it has to be something that's proportionate and appropriate for Jersey. And our banks in Jersey, you talked earlier about the cost of doing business, and if you increase that amount, you also increase potentially the cost for other banks from doing business, because they have to have that contingency.
The scheme is
in
there
mind.
as an insurance policy, so
No, there isn't an insurance policy. It's paid by, it's funded by the banks, and in the initial stages, well, initially I was told when we were doing resolution law that in the vast majority of cases, the vast majority of depositors will always get the money back. But there has to be an interim payment. Now, the government makes an interim loan of 100 million, and the banks, I think, also contribute, don't they? So the more you require to pay out initially,
yeah.
the more demand there is on the loan and
But do you accept the fact that it's going down year on year in real terms?
It's not increasing, but I think it's not necessarily something that you would index link, because I think many people, for very many people, 50,000 would be a vast amount of money to have in the bank.
But it was a lot more.
For some people,
There's a lot more when the scheme
it's a drop
started,
in
though, wasn't
the
it?
ocean. Yeah, yes, but again, it is something that will be reviewed in due course, but it is not on the.
Is there a competitiveness risk here if the UK's got an 85,000 figure, if the EU's got £100,000 as its standard?
I'd be surprised. Well, it's something.
Is there a
I'd be
reputational problem?
surprised.
So-
Because local people are not going to move their money to the UK.
But is it fair just because they can't move their money that they're treated less than they would be elsewhere?
They are not treated less. That's.
Well, they are. It's not that the savings are not guaranteed to the same level. I mean,
So you're asking questions about what does it mean to be a small place with a different infrastructure around you, and I think, as the Minister said, the most important thing actually is that we've got a functioning resolution authority. That means that banks are going to remain liquid and viable, because nobody ever wants to get to the stage where a bank collapses again. And that's why the focus has been on that, and bringing that in together means that they can operate together. And in due course, then once that's bedded in and working, then that's the right time to do a review. But we shouldn't automatically assume that increasing that cap is the right, that will be the right answer coming out of any review.
so at what point would you envisage reviewing the cap?
Well, I don't have we said, didn't we, as Deputy Andrews said, starting the review in 2026. Well, it might take slightly longer than that, but it's about bedding down the new structure and then moving on to that.
Yeah, I think that's where we're looking at doing this. And just to kind of note, you were mentioning about the time difference. £50,000 being set there, that was in an environment where there wasn't a resolution framework, and the resolution framework has obviously been a bit more front and centre of our minds. It's something to deliver on because it is recognised as the more appropriate tool for addressing what a larger or systemic banks, so something with what, using the terminology, has critical functions. So the larger banks, which maybe you or I would bank with, would be considered systemic and global and larger, and therefore resolution would be the more appropriate means of protecting and mitigating the bank failure issues. Nevertheless, we recognise on the face of it, £50,000, you look at it and there's a need to constantly consider the policy position and That's why we mentioned it is something that when we've delivered this stage, we'll then move towards actually considering how that.
But it remains aligned with the other Crown dependents.
Yes, yes.
Minister, we're coming up to time. Can I turn my attention to something which I think is of public interest, which is the situation in Gaza. We know that there is an OCHA going on, you referred to it, with the Minister for International Development, who's also one of your assistant ministers, and I understand that that's given rise to some public interest in Jersey about humanitarian aid. Have you seen an increase in contact from your constituents and from members of the public asking Jersey's government to take some kind of action, or even if it's symbolic, to show discontent or displeasure with Israel?
So I think have I seen more engagement? Probably I've had quite a lot of engagement throughout this period, so it's difficult to say that there's been more per se. But I suppose I sit here and say I fully understand the frustration that islanders feel, and I feel, as I read the analysis of what's actually happening on the ground and the humanitarian outrage of, I'm informed, people actually starving. And I've been clear, as have my ministerial colleagues been clear with the UK government, that they must do absolutely everything that they can to ensure aid gets through. And they've condemned the actions of Israel in its blockade of aid in the strongest possible terms, and I support that. Remind ourselves that the Jersey Overseas Aid Commission is well regarded by UN's OCHA, particularly when it comes to investing in pooled funds, and a lot of the discussions that are being had here on island in Jersey today are talking about how to deal with this humanitarian disaster that none of us wants to see. The tools available to us are, well, as we know, quite limited. I've not only spoken to UK ministers and parliamentarians and written to them on a number of occasions. I've also facilitated other Jersey parliamentarians to speak to UK ministers. The Jersey Overseas Aid yesterday had an update around aid and its ability to get into Gaza. And although they've given to date something like £1 million to support humanitarian activity in Gaza, they are not. Some of that has gone to those who would provide the aid, and they're informed that it's not been able to get through, so it's waiting to access Gaza. They've made a decision to give further aid, but they can't do it at this point because they can't have confidence that that aid is getting through. So today, in light of that decision yesterday at Jersey Overseas Aid, the Minister for International Development and myself have written to the UK Foreign Office, a minister responsible for the Middle East and the minister responsible for international development at the Foreign Office, in strong terms, saying we have aid that should be on its way. Can they do everything within what's possible for them to make sure that that aid gets into Gaza, and that there is a channel of aid into Gaza that doesn't put at risk Palestinians, individuals, and Jersey Overseas Aid rightly are not prepared to use the process that is the one that we're seeing that aid is getting there. But as Palestinians get to that aid, they are being shot. We also, of course, see this afternoon that the UK Foreign Secretary has announced sanctions on two Israeli ministers. We are, as we sit here, I don't know if we've got confirmation that the legal instrument has yet been made. The announcement was made earlier. Once that legal instrument is made, those sanctions will automatically apply here in Jersey.
Do you know who the ministers are? I've not kept up to
those
date.
two individuals. Do we have the?
Yes, it's Ben Gavir and Smotrich, and it will be both travel bans and asset freezes.
So if I come to that point, I mean, we're almost at the end of our allotted time, but in earlier last year, the states did agree, and following your amendment, Minister, that Part C of the proposition was that international law should be adhered to in order to prevent death and harm. And of course, the International Court has issued an arrest warrant for Benjamin Netanyahu as Prime Minister for suspected what we might call war crimes. Would that be? Do you accept the International Court's position on that?
Well, we stand aligned with the UK that accepts the ruling of the international.
Would that be enforced in Jersey? So
What covers the UK is extended to Jersey and would be enforced in Jersey. Yes.
and the decision you talked about from the UK to sanction two other individuals, what implications might that have for Jersey?
Well, as I just said to you, the announcement was made between our two scrutiny hearings. No, actually, when we were in the last private scrutiny hearing, the announcement was made. The legal instrument hadn't been made as I came into this meeting. I've not had confirmation yet that it has been made. As soon as the UK government has made that legal instrument, then it will have automatic effect in Jersey. So those two individuals will be banned from travelling to Jersey, and their assets will be frozen. So that will require industry to review those names and take the relevant action that they do whenever any sanction is implemented.
Okay, and do you think what's happening with the blockade in aid, including potentially aid that Jersey's involved with, do you think that ultimately there's a case for regime change in Israel, and that actually it's the Israeli government which needs to have a change of leadership?
Well, it's not for me to. I try not to get involved in democratic decisions in the United Kingdom, let alone further afield. But it is true that Israel is a democracy, and therefore they are held to the standard of being required to comply with international law, and that international law also covers how they conduct military operations.
Minister, we'll leave that there. I think we've come to time. Do you have any